Okay, welcome to my house. It's Sunday afternoon, and this is odd because you can see me, but I can't actually see myself seeing me. You're going to hear some Hala family sounds. The dog's in the room with me and likes to bark. My daughter is playing the violin, my son is playing the guitar, and my other daughter's in a timeout. So, and the phone will probably ring. We're going to be looking at the Supreme Court today. And right there you have the first Supreme Court, or I shouldn't say the first, the most recent Supreme Court, which is in the basement of the U.S. Congress. And it was a lot darker on the walls back then because they had candles that were lighting the room, and so the smoke would just tarnish the room. They actually had a trial in there, if you've ever seen the movie Amistad. It took place in that room, and it looked much less ornate, of course, than this place, the U.S. Supreme Court today, which is not far from where you're watching this little video that you're loving right now. And if you go to the back of the front of that, you can, it is the great room where they actually do the trials, not the trials, the hearings. And you can see, of course, we got the Greek Corinthian columns that you learned about back in World History 1. Today we're going to look at just a couple slides. We're going to look at start with the Marshall Court. John Marshall is the Supreme Court Chief Justice from 1801 to 1835. Interestingly enough, he actually did not go to law school. There's nothing in the Constitution about having gone to law school. You only need to be appointed by the President and confirmed by the Senate, which he was. He's the longest serving justice, and prior to his tenure, of course, it was not seen as a big deal to be on the U.S. Supreme Court. Most, in fact, preferred the circuit court below it, circuit courts. And he is going to add prestige to it. He's going to do it because of Marbury versus Madison. Now, Madison was supposed to deliver the commission to Marbury for his governmental appointment. Actually, Thomas Jefferson was originally supposed to do it, but he doesn't, and he becomes president, and Madison then refuses to do it. Marbury sues, and it goes to the Supreme Court, and the Supreme Court says no, that Madison does not have to deliver it because they found the law necessitating it unconstitutional. And so judicial review, the precedent of Marbury versus Madison, says you can overturn laws if it goes against what the Supreme Court feels is in the Constitution. And it is the framework by which really all the cases have been done since then. Another early case is McCulloch versus Maryland. That's 1C. And I think I have a picture there. Yep. Sorry, that's Marbury and that's Madison from my previous one. And the state of Maryland wanted to make some revenue off of the Bank of the United States, which was being established in Maryland. So they decided to tax it, its earnings. And so we bring up a couple precedents. One is the elastic clause, the necessary and proper clause, which is in Article 1, Section 8, and it says that Congress can carry out its enumerated powers. In this case, the power is the right to raise revenue. And so if you can one way to raise revenue is by having a Bank of the United States. And so that's the first clause that we're going to use the word later that's incorporated, i.e. the Supreme Court looks at it and says, yes, that's okay to carry out that function. And the second one is the Supremacy Clause, which says that the state of Maryland can't tax the national government. In fact, it would be the other way around, if anything at all. The third case you have there is Gibbons versus Ogden. And Gibbons versus Ogden involves steamboats, which are going to go back and forth between two states on the East Coast. And the question was, the precedent that it established is the control of interstate commerce. And commerce is a power given to the U.S. government to enforce between and amongst the several states. It is odd, let me tell you, that I can't see myself, and I'm wondering how I look for you guys. Probably you're laughing right now. But I'm using the word precedent for these first three cases. A precedent is a standard that is established for the future. In this case, it's Supreme Court cases that are upheld until something is overturning another one. Now today, of course, we have the Roberts Court. John Roberts is the Supreme Court Chief Justice, and you can see him right there. And along with him, you see the other 8 associate justices sitting next to him, and including Elena Kagan, who is the most recent one. And as part of your web quest, you're going to watch this movie, so we're not going to watch it now. The Judiciary Act of 1789 is going to establish 3 levels of the federal judiciary. Or sorry, 2 levels. We already have the Supreme Court. The Constitution says that you can establish inferior courts as necessitated by the Congress. And so the Congress has said that there are 11 Circuit Court of Appeals plus D.C., and they get about 52,000 cases a year, and there are 89,000 district courts in the United States. They're more in the Virgin Islands, Mariana Islands, etc. And then you get Supreme Court. They don't take a lot of cases a year, and we're going to talk about that later. And so you can see the different circuits. They're not equal in size. This one, obviously, the 9th is the biggest one. We're in the 4th. The 4th is considered by and large the most conservative one, and the 9th the most liberal. And now we're almost done. Isn't this great? So there are different areas of jurisdiction. And jurisdiction, if you think the courts, the police shows the 9th jurisdiction or whatever. So jurisdiction is an area of control. So you have original jurisdiction, meaning it's the first time the case has ever been heard, and you have appellate jurisdiction. And most cases are on appeal. So they can start at the federal court in a U.S. district court if it involves a federal question, or it can start in a state court. If it starts in a state court, it would start in the lower level of the state courts, and different states have different levels, and work its way up to the state Supreme Court. And from the state Supreme Court, it goes straight to the U.S. Supreme Court if the U.S. Supreme Court takes it. Otherwise, it goes from the U.S. District Court to the Circuit Court to the Supreme Court. Again, if the Supreme Court takes it. Now, there also are ones of original jurisdiction for the U.S. Supreme Court if they take the case. And so you can see them laid out before you. If Virginia and Maryland, if one sues the other one, and that has happened over control of the Potomac River, mostly controlled by Maryland. If the U.S. government is one of the litigants, and this happens, and a state, if a foreign ambassador or diplomat and some entity in the United States is a litigant, or if citizens from 2 different or more states are litigants, then it has the right to go straight to the Supreme Court, but it doesn't have to. Okay, the last slide we have are the different types of laws, and there are 2. There's criminal and civil, and I have a nice little picture here. And you can see that civil laws cases are carried out between and amongst private entities, people, and whereas criminal is carried out by a state or a federal court. So let's think about someone, if they murdered someone, then it would be up to the state or the locality to indict someone and then prosecute them. And let's say the person was convicted of murder, and so then maybe the victim's family would sue that person. So it would start in criminal court to convict the person, and then civil court would be for the damages. And you can see that to get a conviction in criminal court, it's beyond a reasonable doubt. It's a much higher level than a preponderance of evidence in a civil court. And I think that is it, because the rest of this you're going to do in a web quest. So hope you enjoyed this and you took some good notes and you're ready for the quiz tomorrow. If not, you can just replay it.